Good morning, and welcome to today's VetNet Entrepreneurship Track Hangout entitled Protecting Your Patents and Trademarks in Europe. My name is Mike Schoeneck, and I'm the Program Manager for Boots to Business and VetNet at the Institute for Veterans and Military Families located on the campus of Syracuse University. Before we get started with today's Hangout, I wanted to go through a few logistic details and how to participate. If you're participating live in the Hangout, please feel free to speak up at a given point of the presentation and ask your question directly. I would ask that if you do so, just make sure to mute your microphone when you're not speaking. If you're watching out on our YouTube channel or the event page, please feel free to type your question on that forum, and I'll make sure that your question is then forwarded on to our presenters. So I'd like to first introduce George McGuire, who is the chair of the Intellectual Property Group at Schoeneck King. George, I'll turn things over to you. You can introduce your colleagues, and then we'll get started.
Thank you, Mike. My name is George McGuire. I'm a patent attorney here in the United States, and my colleague from Europe, Aloys Hüttermann, is here today and will provide us with a presentation on protecting the intellectual property rights in Europe. I will turn that over to Aloys. The slides can be brought up.
Thank you. So, can I see the slides now?
Sure. Yeah. If you just click on the box at the bottom of your screen that has the slides, that should bring it up.
Thank you. Good morning, everyone. My name is Aloys Hüttermann from Michalski Partner in Düsseldorf, and I have to thank George and the VetNet for the opportunity to speak a little about European patent law and trademark law and how that works. I would like just very briefly to introduce us and our firm. So can I have the next slide, please? Next slide. Yeah. So we are a patent attorney firm in Germany. And we are deeply based in technology. We still have lots of domestic clients, and we more or less cover all technical fields. Can I have the next slide, please? What we do is drafting and filing patents, trademarks, designs, of course, doing some more like sophisticated or on the top end, like FTO analysis, monitoring, license agreements, and in case that is necessary, we also enforce your rights in litigation, or we try to invalidate other people's patents which surely have been incorrectly granted, penalty actions and the like. Can I have the next slide? So this is our team. So altogether we have 25 patent attorneys, which is for US standard not so big, but in Germany we're top 10. We have 25 of those and 3 consultants, amongst them the former head of the patent department of Henkel, which is a pretty big German chemical firm. Here better known because they have bought Dial. Can I have the next slide? So I'm now going to the presentation, but before I start, I want to have something like a forward. And this is, I think, important to understand how this works. I mean, you are entrepreneurs, you probably don't really care about law. But in order to understand a little how European law works, I think it's important that you think that European law differs from EIP and every jurisdiction simply because we have more than one country and more than one, let's say, institution. So in the US, you have one patent law, you have one Congress, one president who does this, one patent office, and, well, that's complicated enough. But in Europe, you have 10 patent laws, you have European Patent Office, which is based on an international treaty, and you have the European Union, which has the European Court of Justice, and all of that needs to be considered. So if I may have the next slide. So to put an analogy to music, in my opinion, a perfect IP artisan out of Europe is like these two gentlemen. It's Frédéric Chopin or Niccolo Paganini. May I have the next slide? Whereas Inside Europe, you have to think like these two, which is Ludwig van Beethoven and Johannes Brahms. I will explain. Can I have the next slide? So, I'm married to a classical concerto pianist who has studied in Folkwang school, which is one of the 10 best music schools in the world. And of course, she played Chopin a lot. But the thing is that outside of piano, nobody plays Chopin, simply because there are no pieces. So, I mean, you will not have a violinist playing a Chopin violin concerto because there is none. Same with Paganini. Paganini is something like the god for violinists, but no piano player ever played like a Paganini piece. So, this means that they are like the top notch within the instruments. Beethoven and Brahms are pretty different. I mean, of course, Beethoven has written some very relevant piano pieces, but Brahms, for instance, did not. When he did play some piano piece, but you can go to any music school and get rewards, even win like the Tchaikovsky Award in Moscow. I never played a piece of Brahms, but they have written symphonies. So no serious conductor can work without deeply knowing Beethoven's and Brahms' symphonies. And symphonies are orchestra works that you have like dozens of different instruments, so they have to be matched. So instead of concentrating on one instrument, you have to match different. Can I have the next slide? So an USIP artisan has the situation or the privilege to only concentrate on one IP system when he serves clients, or his employer when he's in-house. An European IP artisan cannot do that. He must master several IP systems and must know how to figure that out. Otherwise, potential benefits may be lost. With this forward, I go to the next slide, and we come to the theme of today's presentation, which is protecting your patents and trademarks in Europe. The first part is patents. If I can have the next slide. So, in Europe, there are two patent granting systems which stand side by side. So there's the European Patent Office. The European Patent Office grants European patents. And there are national patent office, which grant national patents. So the thing is that in many countries, like France or UK, patents, they are not examined anymore. They're just registered. Except for Germany. In Germany, we have a still functioning patent office, which does full-scale prosecution like with the USPTO. Can I have the next slide? So, to further complicate, the EUIPO is not a member of the EU. It is based on the so-called European Patent Organization. And the EUIPO grants patent for the countries which are members of this organization, and some of them are not in the EU. And to even more complicate things, is that you cannot really get a European patent in the EPO. What you can get is that you have your application allowed with uniform claims, and then you have to decide which of those countries within the European Patent Organization you want to have. This is a process called validation. And depending on which countries you want, there are additional fees, and sometimes you have to pay your translations. And then your European patent splits up into several national patents, which means that then you have to pay annuity for every one of that. Can I have the next slide? So these are the current member states of the European Patent Convention or European Patent Organization. And there are quite a lot of them. There are 38. As you can see here, you have countries like Turkey or Norway or Switzerland, which either are not allowed to join the EU or will never join. So this territory is pretty large. Can I have the next slide? So, as I said, there are some provisions in the European Patent Convention. This is the treaty on which the EPO is based on, which also govern the phase of European patents. I will not go into that detail because that's really fun. But more or less, the European patent is European only in the application phase. And after that, the national patent laws govern, especially when it comes to litigation. Can I have the next slide? So you have at the moment the choice that for a country within Europe, you either file at the EPO and then litigate nationally, or file at the National Patent Office and litigate nationally. That's what you have to do. You have the next slide. So, but there are big changes coming up, which I think are important to know, and that is there will be something like a European patent and a European Patent Court in the future. And this is the unitary patent, the Unified Patent Court. The unitary patent means that after validation, instead of going country by country, you can go to unitary patent, which covers then quite a lot of countries. This patent is not available now, but it will be probably in 1 year. And this is based, to even further complicate things, on EU law. Can I have the next slide? So, the unitary patent will be like one single patent for 26 member states of the EU. The only member state that's out is Spain. But, that's the good thing, you can have it through the EPO. So then, if you file at the EPO, you can then decide you go country by country or go unitary patent. But, together with that, we will in the future have a unified patent court. But I come to that later. Can I have the next slide, please? So, oops, there's a mistake on that slide. Oh, I'm sorry, what should it replace that? These are the countries which are available by the unitary patent. And there's a mistake because Italy should be red. So if you think that Italy is red, then you have all of them. And this is still quite a large territory. You will have this area in the future by one single patent. Can I have the next slide? So the procedure to obtain that is pretty easy. When an European patent is granted, you can then file a request with the European Patent Office that you want to unitary patent protection. And according to the draft, which is now on the table and which is probably going to be accepted, it doesn't even cost you any money. But what you have to keep in mind, if you go for unitary patent, you cannot then go for a national patent. So it's like a double validation will not be possible. Can I have the next slide? So, and also, you don't need to file any translations. What you need to do for a transitional period is when you have your patent in English, then you have to file a translation of the specification either in German or France. It may be possible that, I don't know, if you sue somebody in Poland or in Italy, that you have to then, only for the sake of litigation, file a translation of your patent. But that's not required if you go for the patent. So this is good news. Okay, have the next slide. So, but here, as always, things are a little complicated. Because unitary patent will at the beginning not be available for all of these countries, but for the countries which have ratified the agreement on the court. There are 13 as minimum. Which means that over time this unitary patent will become larger, but this does not mean that your unitary patent, if you get it, will become larger. By the time you get that registered, that's the countries you're going to get. Can I have the next slide? So, in the future, you have the following possibilities. And this depends on the number of the countries which you want to have. So, if you want to have protection like in Germany or France, then you can go for a national filing, or you can go to the EPO filing and then validate nationally, or you can go to the EPO and if it's granted, validate it to a unitary patent. Can I have the next slide? But if you go to Spain or Switzerland, then the third option is not available. So you can have national filing or EPO filing and national validation, but not by unitary patent. Reason is that Spain chose not to join European patents. They did not like that. They even filed a lawsuit against it, but they lost. And Switzerland is not an EU country at the moment, but I don't think that it will be. At least that's why I'm wandering around on this earth. So, can I have the next slide? Now we come to the litigation to explain that. So, at the moment, if you have a patent infringement in Germany, you have to sue Germany. If you have one in the Netherlands, you have to sue the Netherlands. If you have one in France or Great Britain, you have to go to France or Great Britain. There was a short time there when there was like a cross-border injunction possible, but then there was a decision called Gatluck of the European Court of Justice, and then this was more or less ruled out. I should note that 2/3 of our cases at the moment are filed in Germany because we're so good. No, because, well, of course we're good. But because Germany is important, also costs of litigation in Germany are the lowest in Europe. Can I have the next slide? Yeah, you can see here, these are the cases for 2011. And this is the last year when there are detailed numbers available. So in Germany, you have like 1,200 cases. In France, Italy, somewhere around between 250 and 300. In UK and Netherlands, you have around 50. In all other countries, you have 10 or less new cases per year. Okay, the next slide. So, but we will in the future, as I said, a new court, which will then rule European patents. And this new court will be a newly introduced court system with its own rules and jurisdiction, and will be competent for all unitary patents and, the add is important, on existing European patents and applications which are pending on or filed after the day the court starts. And it will be competent for both litigation and invalidation. Can I have the next slide? So, the importance of this court is much, much higher than unified patent because it's not an alternative. It's a replacement of the current system. With unified patent, it's a matter of costs and what countries are you interested in. Then you just pick if you go for unified patent or not. But with the unified patent court, there's no alternative. To complicate things, I'm sorry, it is structurally a little complicated. It's probably, I should say, in Europe, things are complicated a little structurally, but if you work it out, actually the procedures are usually rather easy. And if I make the nasty statements, in the USA it's completely different. The structure is easy, but the procedures are difficult. So, but in Europe, the structure is complicated. So, at the Unified Patent Court, this is based on an international treaty, as I said. And this is expected to be available, well, late 2015 was a little optimistic, but to like within this year. Currently 6 countries, including France, are ratified. Germany and UK must ratify, and they are in the preparation of that. And then we need some other states. But it's accepted that once Germany and UK, which have done already some preparations, are ratified, then like a domino, they will complete it. We have the next slide. So patentees in the future will have the choice to file at the European Patent Office and then litigate at the Patent Court, or file at the National Patent Office and litigate nationally. So the old regime was that either way you file, EPO or national, you have to litigate nationally, but in the future you have to decide. So either go Unified Patent Court or National Court, depending on what patents you have chosen. You have the next slide. There will be a possibility, no, because then things would be pretty harsh, to, let's say, okay, I still want my European patents, which are now to be handled under the current national regime. And you can do that for a transitional phase of 7 years. So when the court comes, I don't know when it comes, but it's probably going to be like within a year from now. Then, for the first 7 years that the court works, you can provide an opt-out, which means you send a request to the court and say, I don't want this court to be competent for my European patent, which then means that you have to go country by country, and also the invalidation is done country by country. It will be possible then for new applications also to declare this right at the time of filing. And this is needed because after the 7 years you cannot opt out anymore, which means that then all patents which are later filed almost dramatically fall under the competence of the Unified Patent Court. Can I have the next slide? So, if the court starts in April 2017, which is realistic, then opt-out can be declared for all then pending patents and applications filed until April, 2024. Because 17 plus 7 is 24, I'm sorry. If no unitary patent is chosen for them. But if you have a patent filed in May 2024, or later, then you cannot do that anymore. The opt-out will be free. But if you have opted out and then think that, oh, the Unified Patent Court is not so bad after all, you can opt in. So it means you can withdraw it. But then it's final. You cannot say, that was a bad idea, I want to opt out again. No, you can reverse once your decision, but then it's fine. Can I have the next slide? So, the Unified Patent Court will be a two-instance procedure with a court of first instance and appeal court. I should mention, this is very important, that to some extent also interim decisions and procedural decisions, while the procedure is running, you may appeal them. Because that's, I think, going to be a very useful tool. It's unclear whether there will be like a revision of the European Court of Justice, like here the Supreme Court. And this because the system was structured so that the European Court of Justice is not competent. And this is why it's based on an international treaty. So, and I should say that one reason why people did that is that they have followed the decisions of the US Supreme Court in patent law, and they say, well, you don't want to have that, something like that. It's unclear at the moment, however, if that really worked. Can I have the next slide? So, course of first instance, there you will have a plurality of courts, probably like 20 or so, from which you more or less can choose from. So you can do forum shopping. And they are divided into 3 categories, and they are local chambers, and this is very easy, it's a code in one country. So each member state has the right to install at least one. We have the next slide. But countries with many infringement cases in the past have the right to have a second chamber up to a maximum of 4. And the threshold is 200 cases. And then another 200 and then another 200. So if you take these case numbers from 2011, and they probably are the same as they are right now, then Germany may have 4, and France and Italy 2. France and Italy have announced that they will not take the second one, but just put up 1 in Paris and Milan. But Germany, that's on the next slide, will have their 4 local chambers, and they will open them up in Düsseldorf, which is going to be the best one. No, I'm not joking. Düsseldorf is the best infringement court in Europe at the moment. 50% of all European cases are handled there. And I have no doubt that this will also go to the Unified Patent Court. Mannheim, Munich, and Hamburg. This was expected because Düsseldorf and Mannheim have like 80% of our cases, and Munich and Hamburg were like political. Can I have the next slide? What you also will have is regional chambers. That that people, countries combine. So this is attractive for countries which so far had only a few cases. So far there has been like a Swedish Baltic regional chamber for the Baltic states and Sweden. There's going to be in Stockholm. And Denmark has announced that maybe they will join this chamber. We'll see if there are more coming up. And then you have one central chamber, with places in Paris, London, and Munich. And if you hear about the Unified Patent Court somewhere in the blogs, people always say, yeah, you have to sue in Munich or Paris and London. This is not true. The central chamber is not competent for patent litigation. It's competent for invalidation. Can I have the next slide? And there, a possible defendant cannot forum shop, because in an invalidation action and an action for the declaration of non-infringement, they must be started at the central chamber. But if you start an action for declaration of non-infringement, the central chamber, then the patentee can even overrule that if he files litigation within 3 months. So if somebody files a declaration of non-infringement at the central chamber, and you have the opinion the central chamber is not good, you rather go to the Düsseldorf court, then you have 3 months to file litigation there, and then like the case is drawn to the Düsseldorf chamber. So the system is somewhat patent friendly. To say it's at least not patent unfriendly. Can I have the next slide? So, in the second instance, we will have one appeal court in Luxembourg. And this will have several senates, but we will have the possibility of an bank decision with the CAC. We will have 50 to 75 judges probably, and we will have usual judges and also technical judges, like they are now at the German Federal Patent Court. I don't know if you have ever experienced that. We have German technical judges there, but it works pretty well. Can I have the next slide? Okay, this was part 1. Now we come to trademarks. Can I have the next slide? The thing is that for patents, we have several systems, and it's no wonder that for trademarks we have that too. We have national and EU-wide trademarks. You have seen that for patents we don't have really a EU patent, because patents are granted by the European Patent Office, which also cover other countries. But for trademarks, this is not the case. We have a really European trademark, one single trademark for the whole EU. That's possible. On the other hand, you can also file individual trademarks for each country. The thing is that the EU trademark is, well, I put on the slide economical, it's quite cheap. So actually, especially non-European users more or less always go to the EU. Can I have the next slide? But, and this is important, both trademark systems are based on the so-called trademark directive of the EU, which means that in the end the law is the same. So both EU trademarks and national marks are governed by the same, let's say, juridical text. It's a little complicated, we're not going into detail, but both for national and European trademarks, the European Court of Justice has the final say. Only the way that it's involved is different. You have the next slide. So if you file a European mark filed at the EUIPO, I should say that this is, the name will be changed in 4 days. So far it's called the Office of the Harmonization of the Internal Market, OHIM, but they have changed the regulation, and in 4 days it will be European Intellectual Property Office, EUIPO. So, and there, European Court of Justice is the final appeal court, which means that if you are an applicant or a proposing party, you can go there. But for national marks, that's not possible. It's like here with the Supreme Court, the national court must deliver that to the European Court of Justice. But this can also be in the first instance, so you don't have to have it appear. Get the next slide. And then the court like stops the procedure, and then they ask the European Court of Justice a question, which is not directed with the case as such, but it's like underlying. The typical question is, you don't have to read this, but there, can a trademark be blah 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 if the composition mark is used? So this is like a very long, complicated question. And then, if we go to the next slide, the court then poses this to the European Court of Justice. The European Court of Justice only answers this question, and then the court continues on the case and says, okay, we now know how to handle this and this aspect, so we now rule like this. So the registration procedure for national as well as European trademarks is very similar. It has to be because the legal basis is the same. We have the next slide. A trademark is only registered for absolute grounds, like here in the US. So if it is a trademark as such, or if it's descriptive, or if like third parties must have the right to use this trademark. Like, I don't know if you want to have Apple for vegetables, that's not possible. Apple for computers is okay. But relative grounds, which means that older trademarks are not taken into account. But owners of these trademarks can file oppositions within a 3-month deadline after publication, both for national as for European trademarks. Which means that if you have a trademark in Europe, you're very well advised to have a watch system. So there are vendors, or there's the possibility to have like a computerized automatic watch system, which is not expensive. And then you get like all new trademark applications of which a computer thinks they're similar. 95% are not, but so you can have an attorney sorting that out, then because it's a little more expensive, or you can do that on your own. The thing is that the 3-month deadline is not prolongable. So if you miss that one, then you have to really go to court, which is of course more expensive. So it's really advisable to have a watch system so you can file opposition. Can I have the next slide? Very important, and this is the big difference to US. In Europe, it's not necessary to have the trademark used before registration, or you don't have to see that there's intention to use it in the near future. And you don't even have to use it. The only thing that you risk is that if the trademark has not been used after 5 years, then it can be cancelled. Or if you oppose a younger mark, then the owner of that trademark can say, look, please show me that you've used your trademarks, and then you can base your position only on those goods and services that are used. You have the next slide. But it's not necessary to show the use. And unlike here in the US, it's also not possible, not necessary, it's also not possible, to show the use when the trademark is renewed. You just pay the fee. So people assume that like 60 or 70% of all registrations would actually have been cancelled. The only reason that nobody cancelled as they're still there is that nobody cares about them. So, but, and this is the last remark, for use, if you actually have to show the use, which sometimes happens if you have a litigation on a position, at the moment there's an unclear situation for European trademarks. I can have the next slide. A European trademark must be used within the EU. But what does that mean? And this is, to be open, not decided. Especially, how many countries? How many countries do you have to use that? So there's case law that a smaller country like Austria is not sufficient. So there's a ruling by the European Court of Justice that Austria is not enough. On the other hand, it is clear that in order to show proper use, you don't have to use it in every country. I mean, you don't have to show that your trademark is used in Malta or Estonia or so. So, I mean, because then hardly ever any trademark would survive a cancellation request. Maybe like the bigger ones, maybe a Porsche or Coca-Cola. So they survive, but not your trademarks. So if you ask me, I would say, okay, if you use like two bigger countries, like Germany or France and Great Britain, or France and Spain, that should be okay. But this, of course, means that if you intend to be on the market only for Germany, then you better maybe offer the German national mark. And then that's possible. If you then expand to another country, then you file an EU mark. Can I have the next slide? A litigation of trademarks. Here, it is so that we will not have a European trademark court like the UPC for patents. Litigation of trademarks must be done at national courts. This is regardless whether it is European or national mark. So if you summarize the trademark system in Europe, it's not as complex as the patent system. It is a little complex, though. The only thing that I would say is a take-home message is that in Europe, the biggest difference is that the use of the mark does not need to be proven actively. You can just register it, and as long as nobody attacks it, it can be only registered. Which means that if you register it now, nothing happens for 6 years, and then you use the trademark, then that's very fine. Because you only have to show use for the last years. You don't have to show that if somebody attacks your mark that you have used it like for the last 30 years. Can I have the next slide? Thank you very much.
Hey, thank you very much. That was very informative and useful, and we will make sure that we get you all over the YouTube link with the recorded presentation, as well as we share this with all of our graduates across the IVMF programs. We do have a number of individuals who are still in Europe operating, so this will be extremely useful for them. George, do you have any closing comments you'd like to make before we close out? And I will make sure with Jim that we have no question out there right now.
Yeah. The question that just popped up: is there any way to follow up with questions? Certainly, one way to follow up is by email. You can email me at McGuire, McGuire @bsk.com. And Aloys's email is on the slideshow.
Yes.
You can always email Aloys. It's a GUIRE @bsk as opposed to W. MCGUIRE. I just saw it pop up. Yes, that's right. Yeah, correct. The other thing I'll mention, I know I'm helping out. For example, currently I'm helping out a graduate from the Veterans Institute from Purdue University on some patent matters. He happens to be stationed in Poland right now. He was injured, came back to the United States, went through rehabilitation, and has been redeployed over to Poland. He's starting his business while he's over in Europe. I imagine a lot of our veterans who have been stationed in Germany or other European countries have networks established over there and understand the principles of the economies in the various European countries. So I would suspect, to the extent there's ambitions for the startup businesses to be greater than just United States domestic, Europe would be a natural extension. The protection of intellectual property for these businesses is going to be very important. It's necessary to make sure when you're starting your businesses that you pay attention to the intellectual property protection before you start launching products and offering services. You want to make sure you have the right to do what it is that your business is going to be doing. And to the extent you start your businesses and start operating and start commercializing, you may lose valuable intellectual property rights as a consequence of not pursuing the intellectual property protection earlier in time. Especially in Europe, which is what we would refer to as absolute novelty, you need to have your patent filings done before any real commercialization occurs. So it's a good tip to at least be cognizant of the intellectual property issues and the timing that's involved with them. The other thing I'll mention, this difference between the current European patent, where you have to go through the validation procedures in the national countries, it's very, very, very expensive if you want a lot of European countries to have the validation in. The unified patent, it's my understanding, is going to be far more economical.
Yes,
when you validate as a unified patent,
yep,
the cost will be significantly lower
yeah,
than they currently are.
Yes.
So, for instance, if you choose to validate your allowed European patent in 15 countries throughout Europe, you're probably talking, $60,000 to $70,000
yeah.
to do that kind of a validation. The unified patent, I don't think is going to be anywhere near those costs.
No. It's like lower than 10% of those costs, because you save. You don't have to file translations. You don't have to involve national attorneys. You have annuities, but they're nowhere near that. So this is really economical.
Yeah, so
that's a good thing.
It's a very good thing for U.S. businesses that are protecting over in Europe and aren't quite sure, whether they're going to go to Iceland or not, for instance, or some of the more smaller economies in Europe. Right now, if you want to go into those countries, you still have, you gotta get the translation into the national language, which is a huge expense, and you've got to pay the lawyers in those countries, and you've got to pay the national fees in those countries. So the unified patent will allow much more economical extension of the patent rights throughout the EU. So that'll be a good thing when it comes into being for U.S. applicants in particular. So I did want to just mention that. But again, follow-up questions, feel free to email or call.
And may I add one thing? This is important because the system is different. And so this is a mistake that many U.S. applicants make is for trademarks. So the thing is, if you plan to go to Europe, then you can now file a trademark even though you're not on the market. And that's what all European applicants do. Like they file their trademarks like on stock. This is not possible in the US because there you have to, within a very short time, show the use. But in Europe it is possible, and if you don't do that, it may be that at the moment you enter the market, the name of your product is already protected by somebody else. So if you plan to go to Europe, then actually one of the first steps you should undertake is that you file a trademark. Even though you think that you may not enter in like 3 or 4 years or so, still you should file or think about trademark protection now. And the thing is that we're not talking about a lot of money here. So you can have a European trademark for less than $2,000. So, but that may be crucial because since in Europe the use requirements are not so harsh, it may be that that's already has been registered with someone else, and then you are really in a bad position.
Thank you very much. And again, as I look at my program, Boots to Business in particular, we operate in about 12 countries over in Europe and Asia at the U.S. military installations. And we do see a large population who, once they separate, stay over, particularly in the EU. So I will make sure to get this presentation out to them as they pursue their ventures. And George, through IVMF, if we receive any direct inquiries to myself or the team, I'll make sure to forward them on to you.
Thank you.
Perfect. Thank you very much.
Thank you.
Absolutely. So Again, I'd really like to thank you all for taking the time this morning to join us and provide this presentation on a topic that is extremely important for those of you out there who may be looking to operate in Europe, to make sure that you have all your ducks in a row prior to launching and going into business.
There's a question. Okay, it was about business models. So the thing is that in the US you have the Alice decision, which means that concerning software and business method, the US is now stricter than the EPO. So, you cannot get business method patents in the EPO, but you cannot get it in the US either. You can have to somewhere extend software patents in the EPO, which you cannot at the moment in the US. So, but it is possible to patent software as long as there is like a technical relation.
It's very, very similar in the US and Europe now with regard to software-related invention. Pure business methods are difficult in the US now since a Supreme Court decision of a year and a half ago or so. Oftentimes, though, the business method truly is a computing system. And if the patent application is drafted appropriately in terms of the computing system, oftentimes we can overcome the subject matter issues that the Alice decision at the Supreme Court raised. And similarly in Europe, when you can prove the technical components to the computing system, it can be protected. If what you're trying to do is protect the very, very high level business methodology that's implemented by the computer, that's difficult in the US as in Europe. But again, sometimes you have to drill down a little bit deeper into the technical features of the invention, because most often there is something inventive about the software that's driving the system.
Yes.
And when you describe the invention in terms of the software-related components, quite often it can be protectable in both the US and in Europe.
Thank you very much, and thank you for the question. Jim, do we have any other questions out there at this time? Okay, so no other questions out there. I will turn it over one more time.
Hold on, Mike, there is one actually.
Okay, so we'll put that question in the chat box. Okay, so this question says, in reference to trademarks, what minimum differences must be met of a similar trademark in order to avoid infringement, i.e., EU has a logo composed of 12 stars of one color. Would a similar logo of different colors, 24 stars, etc., meet the requirement?
Yeah, so the thing is that actually I would say that the situation here concerning this, like confusing, is in Europe as in the US is pretty similar. So to answer this question, I would say that a 24-star would not be accepted if there's a 12-star. That would be considered too close. Of course, this really depends on the situation. So, like famous trademarks enjoy a higher level of protection. So, if, for instance, if you want to have a trademark for cars that's called like B and X, no, B and X is a bad example. Like B and Z, there's BMW, then yeah, that's not so good. Of course, this has to be decided on a case-by-case basis. So the rule of thumb, I would say, is that your experience in the US with similarities are pretty much that what you can expect in Europe. Which means is that if you have identical goods, then you have to have a lower, higher, let's say, a higher space. But if the goods are not so close, then they can become closer. And I mean, and if the goods are totally separate, then even the marks will be identical. So they're like, and I mean, everybody knows about the Apple and Apple. So, which is where there has been a lawsuit between Apple from the Beatles and Apple from California. But for instance, in Germany, there's a famous example called Knorr. There's a company called Knorr. They make brakes. So if you ever ride on a train, the train brake will come from Knorr worldwide. And there's also a company, Knorr, which now belongs to Unilever, but used to be separated, where they make like food. So and these two companies exist for more like over 150 years. And of course, their trademarks are not considered similar, although they're exactly the same because the goods are separate. So this is how it works. And of course, if you come up with a real case, one has to look at it how it really is. So there's always some like tolerance which you have to accept. But I would say that the case law is pretty much similar to this.
And in the U.S., the standard is whether a consumer would likely be confused into thinking that the source of origin of the goods or services in question are common. So it's not you don't have to prove that there's actually been confusion in the marketplace, but you need to prove that consumers are likely to become confused. And again, so there's lots of factors that come into play: the similarity of the marks, the similarity of the goods or services, the similarity of the market channels through which the goods or services travel, the sophistication of the consumer. So a consumer of very expensive items, for instance, or a professional buyer, for instance, is going to take more care in the purchasing decision than a consumer of low-cost items where they might just see the brand and grab it off of the shelf of the store. So these are just some of the factors that go into the calculus. But again, the standard is whether consumers would become confused.
And the standard in the EU is exactly the same. And then also the factors that are considered are the same.
Thank you very much. Any other questions, Jim?
No, right now.
Okay, great. So we have the contact information for both parties that are presented today. We have George's in the chat function, and we have the other in the slideshow. So we'll make sure that all parties have that who may have watched or may watch in the future. You can also feel free to contact me directly, Mike Schoeneck at meschhoen@syr.edu, and I can put you in touch with either two if you have any questions. Other than that, George, I think we're good to close out on our end, unless you all have anything else you'd like to cover.
No, thank you very much. I think we're good.
Thank you very much.
Absolutely. Thank you, and have a great day and safe travels to our friends from Germany.
Thank you.
Have a great day.
Yes, thank you. You too.
Thank you.